Hello and welcome to my group's video presentation for the topic of causation. The subtopics we will be discussing for causation are the but-for test, legal causation and novus actus interveniens. We will also be discussing the key cases for each topic. Under novus actus interveniens, we will discuss how the chain of causation may be broken in three ways: through a naturally occurring intervention, act of a third party, and finally, failure to seek medical treatment. With regards to legal causation, we will discuss the eggshell rule as a principle of causation. For the but-for test, we will discuss how people are legally responsible for their actions.
There are two types of causation in the law: cause in fact and proximate cause. Cause in fact is determined by the but-for test. The but-for test inquires, but for the defendant's acts, would the harm have occurred? If A shoots and wounds B, we ask, but for A's act, would B have been wounded? The answer is no, so we conclude that A caused the harm to B. The but-for test is a test of necessity. It asks, was it necessary for the defendant's act to have occurred for the harm to have occurred? One weakness in the but-for test arises in the situations where each of several acts alone are not sufficient to cause the harm. For example, if A and B fire what alone would be fatal shots at C at approximately the same time, and C dies, it becomes impossible to say that but for A's shots or but for B's shots alone, C would have died. The courts have generally accepted the but-for test, notwithstanding these weaknesses, qualifying it by saying that causation is to be understood as the man on the street would. We see this in the case of Yorkshire Dale Steamship Co. versus Minister for War Transport in 1942, or by supplementing it with common sense.
There are several prominent cases centred around the but-for test in Irish common law. Barnett v Chelsea and Kensington Hospital from 1969 is a key English case that has had a big impact on all Irish tort law. In it, a man came to Chelsea and Kensington Hospital suffering from arsenic poisoning. He was seen by a nurse who concluded that he was suffering from alcohol poisoning. When seen by a doctor, the doctor agreed with the nurse. The patient later died from the arsenic poisoning. The case was brought to court with the plaintiffs claiming that but for their negligent treatment, the man would have survived. However, the court ruled that had he gotten proper treatment, he still would have likely died. Umper versus Carroll and Wexford County Council from 1986 is an important Irish case for the but-for test. The clearance under a particular bridge was 15 feet, but after years of retarring, it had reduced to 14 feet. But no signpost clarified this. When a truck hit the bridge, it caused damage to the railway track above it, and Umper claimed that but for Wexford County Council's negligence in their failing to warn road users about this change in height, the accident would not have happened. The High Court agreed with Umper, but the Supreme Court subsequently overturned their decision, citing the driver's ignorance of the height of his truck. The court said that because of this, the accident was still likely to have happened.
The eggshell skull rule is one of the four principles of causation. This rule states that the victim must be taken as found. Basically, this means that the frailty of the injured person must be taken into account. It is a well-established legal doctrine used in some tort law systems, with a similar doctrine used in criminal law. This rule can be seen demonstrated in the case of Orr versus McKetchin. In this case, McKetchin attacked an elderly man. In hospital, it was discovered that the man had a stomach ulcer. As the man had received brain damage from the attack, the ulcer could not be treated, and he died. It was found that McKetchin caused the death, as although the ulcer may not have been discovered if not for McKetchin causing the hospital visit, and the man would likely not have died from the inflicted injuries alone, it is for a defendant to take a victim as he finds him. The brain damage was a substantial cause of death, as it prevented life-saving treatment.
It cannot be the sole purpose of the resulting harm, but it must be more than minimal. Legal causation requires that the harm of the victim must result from a culpable act. There can, however, be more than one substantial act or main cause resulting in the victim's death. In the case of Davis, convicted of murder, appealed on the grounds that there was insufficient evidence that the victim's death was as a result of his actions. The applicant claimed that the deceased had fallen down the stairs following his attack, which is what severely injured her. Regardless of the stairs incident, the cause of death was in fact heart failure, secondary to severe shock, which was the cumulative result of the pelvic injuries and ruptured bladder incurred following Davis's brutal assault. Davis was found guilty of murder. This case demonstrates the principle that the act need not be the sole purpose or main cause.
Different tests can be applied to decide if the chain of causation has been broken depending on the intervening party. One of the tests that can be applied is in relation to medical treatment. In the case of R versus Jordan, the chain of causation was broken. The defendant stabbed the victim. The victim was then taken to hospital where he suffered an allergic reaction to antibiotics. He died of pneumonia in hospital 8 days later. At the time of the death, the stab wound was starting to heal. The court found that the victim died of medical treatment. This broke the chain of causation and the defendant was not liable for the victim's death. Another test that can be applied is the one regarding the failure to seek medical treatment on behalf of the victim. In the case of R versus Flynn, the defendant threw a stone at the victim. The victim then walked 2 miles to a police station and the following day rode a horse. He then died 4 days later. Failure to seek medical attention was not a novus actus interveniens, as the victim carried on with his day as normal. The neglect on the victim's behalf to care for his injuries did not serve to break the chain of causation. Furthermore, another test that can be applied to decide if the chain of causation has been broken is one where the victim is the intervening act. In the case of R versus Roberts, the defendant tried to assault a girl in a moving vehicle. She jumped out of the car and was injured. Her actions had been foreseeable, so there was no break in the chain of causation.
Actus interveniens, or the intervening act, may break the chain of causation under 3 circumstances: naturally occurring intervention, act of a third party, and failure to seek medical treatment. Under the first circumstance, the act in question must be an operation of natural forces so unpredictable as to excuse a defendant all liability for its consequences, as stated in the Southern Water Authority versus Pegram. The act of a third party is the second circumstance, with the question of was the action free and voluntary. In Paget, the defendant used his 18-year-old girlfriend as a human shield in a shootout with the police. He was convicted of manslaughter. The police shot involuntarily in self-defense. In Gerlder, the results of hitting a taxi were not reasonably foreseeable, as he could not foresee that the third car would also crash. In Attorney General versus McGrath, an old man who was in a fight was left on the side of the road. A doctor found him and left to call an ambulance. A group of passerbys brought him to a hospital where he died from blood in his lungs. The passerbys were a link in the chain, but they did not break the chain of causation.
The second principle of causation is that the cause must be operating at the time of the result. This is shown in the case of R.V. Smith in 1959. The soldier was stabbed outside a barracks and then dropped on the way to the hospital, where he also received the wrong medical treatment from a misdiagnosis, but the stabbing was still operating. This case established that if, at the time of death, the original wound is still an operating cause and a substantial cause, then death can properly be said to be the result of the original wound, even though another cause is still operating at the same time.
Act must be shown for a defendant to be guilty. This test is used to decide whether someone is criminally liable or not. The key case on the culpable act is the case of Dalloway. In this case, the defendant was driving a cart and was not holding the reins. A small child ran in front of the car and was killed. It was found that if the defendant had the reins, he could have saved the child, and if he had been holding the reins and didn't stop the cart, his actions would have constituted manslaughter. However, because he was not holding the reins, there was nothing he could do. He was found not to be criminally liable. Moving on to the principles of causation. The first is called the de minimis principle. This means the act must be more than a minimal cause. Causation is not established where the treatment of the victim was so remote from the defendant's act that their contribution is insignificant. R.V. Adams is the key case on this topic. In this case, the defendant was charged with easing the passing of elderly patients. He was acquitted of murder because his actions only minimally contributed to the patient's death.